Hello friends, Namaskaram, how are you? Myself is Dr. Soni, I am an advocate. In today's class, we will discuss the fundamentals to get the bail. I know that it is not easier to get the bail from the consent court because whenever you are going to argue for the bail, the consent PP will argue that the offense is serious, he is not cooperating, he is absconding, he is going to temper the evidences, and lot of argument he could made against you. So whenever he is arguing and you are not able to address your case specifically, what you will get? Zero unda, dismissal. Do you really want to get zero unda in your case? If you're not willing, then follow certain fundamentals, then you could easily put up your case for bail before the consent court. Whenever you are going to argue your case for bail, more specifically in a cybercrime, first of all, we have to understand what FIR says about you. If there is nothing about you in the FIR, means there is no specification, allegations are general, and apart from that, you are not named in the FIR. FIR is delayed. Do you think that you are having a very good case for bail? Tell. Answer is in affirmative. If the said scenario occurs, in that scenario, you are having a very good case for bail. So if there is non-specification of your role, the allegations are concocted, the allegations are general, allegations are unspecific, the chance to get the bail would be on dominant side. And in addition to this, if the FIR is delayed and you are not named in the FIR, the scenario appears, the prosecution is going to add fuel to the fire. They are going to help you. So with the help of these fundamentals, you could put up your case. And in addition to this, I am discussing one of the most important cases of inclining of bail in favor of accused decided by Honorable Gujarat High Court. Judgment date is 27th of Feb 2026. In that case, a FIR has been registered as per section 317, section 61 subclause 2 of BNS, and apart from that, section 66 subclause D of Information Technology Act is also added. So whenever we are indulged in a cybercrime, it is next to impossible to get the bill. But it is not my belief. It is belief of prosecution. Because prosecution says that you are culprit, you are liable to be detained in the custody. But do we think that prosecution is right in its approach? The answer is in negative. Because liberty is the fundamental right. It could not be compromised in the easier way. So whenever your liberty is going to be compromised, simply do one thing. Just read the sections in the FIR. It is easier now. And do one thing. Subsequent thereto, simply type the sections on Google just to find out what is the quantum of imprisonment. If the imprisonment is less than 7 years or it is up to 7 years, the concerned police is bound to serve you a notice as per section 35 subclause 3 of BNSS if notice is not given, and simply the arrest is effected. It is in mechanical manner. In that scenario, there is a violation of guidelines of Honorable Supreme Court verdict, that is Arnesh Kumar versus State of BR. Judgment date is 2nd of July 2014. We could have the benefit. Simply we have to understand the legal compliances. We have to understand the fundamentals. Every accused shall be deemed to be innocent unless proven guilty. Even you could argue in your case that if you are innocent, then how it could be presumed that you are culprit. So if you are innocent, you deserve the bail. And apart from that, what explanation you are going to accord to the allegations of the prosecution? If you are not having any explanation, in that scenario, you might be in the hot water. So I request all of you, whenever there is a FIR against you, simply give the explanation. If your role is not specific, there is no mentioning of your name, there is no role of you in the FIR, you will have the benefit. And apart from that, you are charge sheeted. And after filing of charge sheet, you are going to move for the bail. Find out what is your role. If your role is not specific, it is unclear, it is general, and simply with the help of 61 subclause 2 of BNS, you are connected. The chance to get the bail will be on the dominant side. In that case, the accused submitted that he is not having the criminal antecedents. He submitted that he is not the beneficiary in the crime. Nothing has been received in his account. When the allegations are not specific, allegations are omnibus, allegations are general, there is no evidence on record to corroborate the allegations of the prosecution. In that scenario, the accused deserves the bail. And apart from that, the accused relied on one of the most important judgment of Honorable Supreme Court, that is Sanjay Chandra versus CBI. Citation is 2012, Volume 1, SCC, page 40. In that scenario, Honorable Supreme Court specified that the basic rule is of bail, not jail. So whenever you are confined and you are having such contentions and you submit a petition which is totally structured, oriented, and there is specification what legal provisions are violated and what factual scores never constitute any offense against you, in that scenario the chance to get the bail would be on the dominant side. So I request all of you to follow this fundamental while drafting the petition. The chance to get the bail would be on dominant side. So there is nothing to worry. You are accused as per prosecution, but we are innocent as per our own understanding and as per the understanding of law. So simply we have to put up our case so that we could address the case before the honorable court and could be succeeded accordingly. See you in the next lecture. Till then, Jai Hind, Jai Bharat.